Hello and welcome to the December 2022 episode of My PIP Monthly. As always, my name is Amber Rouse Holloway and I'm a partner here at our Troy office. Our December 2022 topics will include a case law update. First, we'll talk about Bakeman v. Citizens Insurance Company of the Midwest. This is a soon-to-be published opinion. Next up, we'll discuss Ophelia Epps and Michigan Head and Spine Institute v. United Services Automobile Association, and that is an unpublished opinion. And then lastly, we'll discuss Waysick v. Auto Club Insurance Association, and this one is also to be published. Then we will move forward, as always, with trending topics in PIP litigation. And I wanted to provide an and area update, specifically talking about this recent unpublished opinion of Spine Specialists of Michigan v. Member Select Insurance Company. First up, we have the case of Bakeman v. Citizens Insurance Company of the Midwest, and this opinion will eventually be published. Here, this case centers around the fact that plaintiff committed a fraudulent act when he knowingly signed and submitted false statements and claims regarding PIP benefits. Here, the Michigan Court of Appeals held that plaintiff committed a fraudulent act and that summary disposition in the underlying court was properly granted in favor of defendant. Just for a quick background on this one, the plaintiff was injured in a single vehicle accident. Neither plaintiff nor the driver had a no-fault insurance policy, so then plaintiff sought benefits through the MI PIP, or the Michigan Automobile Insurance Placement Facility. These benefits were administered by defendant here, Citizens Insurance Company of the Midwest. Subsequently, the plaintiff was hospitalized for approximately 6 weeks, following which he was prescribed attendant care and household services 7 days a week, 12 hours per day. After his video deposition, plaintiff testified to receiving attendant care services 8 hours a day, 5 days per week from March through May of 2019. However, the claim forms that were submitted to Citizens claimed 12 hours a day, 7 days per week during that time period. Plaintiff's signature was on the form submitted to defendant, and plaintiff testified that he didn't sign any of these forms and answered he believed so when asked whether his signature had been copied onto the forms by someone else. And in further contradiction of plaintiff's own testimony, plaintiff agreed that it was indeed his signature on the forms later on in that same deposition. Now here, entitlement to benefits through the MI PIP is governed by MCL 3173A, where a person commits a fraudulent insurance act when 1, that person presents or causes to be presented an oral or written statement, 2, the statement is part of or in support of a claim for no-fault benefits, and 3, the claim for benefits was submitted to the MI PIP. And then number 4, the person must have known the statement contained false information. And lastly, the statement concerned a fact or thing material to the claim. And that's the case of Candler v. Farm Bureau. Also, in conjunction with this case law, the case of Dykes v. William Beaumont Hospital, where it was well established in that case that a party or witness may not manufacture a question of material fact by directly contradicting the person's own direct deposition testimony with an affidavit. Consistent with that rationale, a party may provide an affidavit to explain, clarify, or expand upon their deposition testimony, especially where the deposition testimony was not equivocal or unequivocal. Now, defendant filed their motion for summary disposition, arguing that plaintiff's claims were fraudulent due to the inconsistencies in the deposition testimony, the affidavit, services that were provided, and the prescription. Here, it's important to note that the rule regarding conflicts between depositions and affidavits was designed to prevent parties from manufacturing factual questions for the purpose of surviving summary disposition. Moreover, the Court of Appeals has adopted a case-by-case approach when analyzing arguably inconsistent deposition testimony. Here, plaintiff's argument was that 1, there was no evidence that plaintiff had any intent to defraud the MI PIP, or 2, the errors in the form were immaterial, and then lastly, that he did not sign the forms nor did he review the forms after they were filled out. Ultimately, the Court of Appeals first determined that plaintiff's subjective intent was irrelevant, and the critical concern here was that plaintiff knew that the false material information had been provided to Citizens. Secondly, the identity of the service provider was material to plaintiff's claim. And third, plaintiff cannot rely upon a lack of knowledge of the contents of the form, because the law is clear that one who signs an agreement in absence of coercion, mistake, or fraud is presumed to know the nature of the document and to understand its context. So some big takeaways from this case: it is well established that self-conflicting testimony does not allow a party to manufacture a question of material fact. Here, courts should not presume that either of two arguable contradictory statements is the true one, and that the Court of Appeals here took a case-by-case approach to analyzing inconsistent deposition testimony. But more specifically in this case, the careful review of plaintiff's self-conflicting deposition testimony and the affidavit could have only been resolved with the determination that plaintiff committed a fraudulent act one way or another. So ultimately, the Court of Appeals did affirm the lower court's ruling, which was in favor of defendant citizens for summary disposition. Next up, we have the case of Ophelia Epps and Michigan Head and Spine Institute v. United Services Automobile Association. And again, this is an unpublished opinion of the Court of Appeals. Here, ultimately, the Court of Appeals determined that a plaintiff's vehicle registration, rather than a plaintiff's residency status, controls whether a plaintiff is required to maintain Michigan no-fault insurance to recover tort damages arising from an accident in the state of Michigan. Ultimately, the court decided that if a plaintiff registers a vehicle in Michigan, he or she must also maintain a Michigan no-fault policy to recover tort benefits or tort damages. By way of background, the plaintiff here was a Georgia resident and involved in a 3-car accident while visiting Michigan. Again, the Michigan Court of Appeals held that plaintiff's vehicle registration, rather than plaintiff's residency status, control whether plaintiff was required to maintain Michigan no-fault coverage. The main issue here was whether plaintiff, despite being a resident of Georgia and maintaining Georgia insurance, was required to maintain Michigan no-fault insurance policy after voluntarily registering his vehicle or the vehicle with the state of Michigan. It's important to know here that the owner or registrant of a vehicle involved in an accident is not entitled to PIP benefits if he or she fails to fulfill the conditions mandated by the Act. In other words, the owner or registrant's insurance is ineffective when it comes to recovering PIP benefits if he or she fails to satisfy the terms set forth in the No-Fault Act. Likewise, a party may not recover tort damages arising out of an automobile accident if, at the time the party was operating the vehicle, he or she failed to comply with the conditions of the No-Fault Act. So the same rule for PIP that applies for tort as well. Here, the Court of Appeals explained that in conjunction with maintaining no-fault insurance, a Michigan resident must register his or her vehicle with the state to be entitled to recover Michigan PIP benefits and or tort benefits or tort damages. If not, the party's insurance is ineffective and he or she will not be entitled to recover. However, the court did give the caveat that non-residents who own a motor vehicle registered in another state are generally exempt from Michigan's registration requirements. Consequently, plaintiff in this case argued that because she was a resident of Georgia, she was not required to register the vehicle in Michigan. It's important to note also that she did register the vehicle in Michigan, but she did so voluntarily. Plaintiff further argued that because she was not required to register the vehicle in Michigan, she was not expected to maintain Michigan no-fault insurance. And she was not required to maintain that insurance in order to recover tort benefits. So taking all that together, plaintiff has asserted that because she was a non-resident, she was not required to comply with the provisions of the No-Fault Act in order to recover tort damages, but she should still be able to recover those tort damages. Ultimately, the Court of Appeals did not agree with that argument and clarified that non-resident owners are still required to register their vehicle in Michigan under certain circumstances. For instances, Michigan residents must register their vehicles to maintain adequate insurance under the Act, and out-of-state residents must obtain no-fault coverage if they operate a vehicle in Michigan for more than 30 days in a calendar year. Now, the key in this case is that plaintiff did voluntarily register her vehicle in Michigan, and therefore she was required to maintain Michigan no-fault benefits in order to seek tort damages. And last up for our case law update, we have the case of Wasig v. Auto Club Insurance Association. Now, this case is a somewhat interesting one. Here, the Court of Appeals defined the phrase hit and run vehicle in the context of an auto insurance policy, or specifically this auto insurance policy. Here, the underlying policy failed to define the term hit and run vehicle, and then the Court of Appeals had to determine its plain and ordinary meaning in order to determine the outcome of this case. The court did first note that because uninsured motorist coverage is optional, the terms of the agreement are covered or controlled by the subject policy, and therefore not mandated by statute, as the coverage is optional. And a quick background on this one, the plaintiff here was a passenger in a vehicle driven by his girlfriend. Their car was rear-ended by a Ford Explorer. Both drivers turned on their hazards, and then the Explorer followed plaintiff's girlfriend's car into the nearest parking lot. There, both drivers inspected their vehicles and ensured that there were no injuries. Plaintiff's girlfriend assured the driver of the Explorer that there was no damage to her car, and both drivers mutually agreed that there was no need to contact the police. They both left the scene without exchanging information. Soon after, the plaintiff here was diagnosed with a concussion. He sought uninsured motorist benefits under both his and his girlfriend's auto insurance policies. Both parties included coverage in situations where, 1, there was a hit-and-run vehicle, and 2, whose owner and operator were unknown, and 3, that made direct physical contact with the vehicle plaintiff was occupying. Now, both carriers here moved for summary disposition on the basis that the coverage was not available because the Explorer was not a hit-and-run vehicle under the common meaning of the phrase. They pointed to the fact that both drivers stopped and talked to each other after the accident and decided not to call the police and decided not to exchange information. So, but for that decision, it wouldn't have been a hit-and-run vehicle. They would have known the insurer of the vehicle. Again, the court cited the Dufresne v. State Farm case and noted that language in the policy primarily controls this situation. Unfortunately, neither of the policies here define the actual term hit and run, but the court did articulate a definition based on both the common understanding of the term and the policy language that was included. A hit-and-run vehicle is a vehicle that hits another vehicle and the driver leaves the scene of the accident either without stopping or at any time before an exchange of information takes place. The court emphasized that the run has to occur before the opportunity to exchange information can take place. The court also noted that this type of run typically occurs if a vehicle flees without stopping, or if the vehicle stops but leaves before there is an opportunity to exchange information. Now, in this case, because the driver of the other vehicle only left the scene after talking to plaintiff's girlfriend and both drivers agreed not to contact the police or exchange information, the Explorer was not a hit-and-run vehicle, and therefore plaintiff was not entitled to UN benefits under either policy. Okay, moving on to trending topics in PIP litigation. I wanted to give you guys an Andary update, specifically discussing this unpublished opinion of Spine Specialists of Michigan v. Member Select Insurance Company. Now, we all know that the Court of Appeals held that the 2019 amendments to the Michigan No-Fault Act do not apply retroactively to claims arising from motor vehicle accidents, which occurred prior to June 11, 2019. And that's the big takeaway from Andary. But per the Court of Appeals holding, if an individual sustained injury in a motor vehicle accident before June 11, 2019, MCL 500-3157 Section 7 and MCL 500-3157 Section 10 may not be applied to limit such individuals' no-fault benefits. Now, Andary addresses fee schedules, providers' reimbursements for services not covered by Medicare, and also attendant care, but not replacement services. Now, here the plaintiff sought payment of first-party no-fault benefits from defendant for medical care provided to the underlying claimant, provided by plaintiff, and provided to defendant's insured, Jeremy Woods. Ultimately, the Michigan Court of Appeals held that plaintiff's claims were barred by the pre-amended version of the one-year back rule, MCL 500-3145, because plaintiff's claims accrued before the amended statute went into effect, which does not apply retroactively. Now, under the pre-amended version of the Michigan one-year back rule, which is 3145, because plaintiffs sought payment for medical care provided to Mr. Woods in April and May of June of 2019, in an action that commenced in September of 2020, 1 year after the date of which plaintiff incurred the allowable expenses, the court deemed that plaintiff's claims were barred as untimely by the one-year back rule. Now here, in defense of this, the plaintiff cited Michigan's enactment of 2019 PA 21 and its provision that amended the one-year back rule effective June 11, 2019. But the Court of Appeals rejected that argument, which was essentially plaintiff's attempt to apply the amended one-year back rule retroactively. Here, the court reasoned that because the No Fault Act provides a specific accrual statute that defines when PIP benefits are accrued, that the statute must be applied when a plaintiff seeks PIP benefits, as is in the case in this action. MCL 500-3110 Section 4 provides that PIP benefits payable for injuries accrue not when the injury occurs, but as the allowable expense is incurred. The Michigan Court of Appeals, as we all know, previously determined that when applying that statute, an expense is incurred or a patient becomes liable when an agreement to pay is executed and treatment is received, not the date of the accident. Taken together, Spine Specialists of Michigan, taken with the Andary statute, essentially shows that Michigan Court of Appeals are no longer entertaining any attempt to retroactively apply amendments to the No Fault Act. And of course, this is going both ways at the detriment of, for example, defendants or insurance companies, and at the potential detriment of plaintiffs as well. And that's all I have for you guys today. As always, my name is Amber Rouse Holloway. I welcome any questions and or concerns, and I will talk to you guys again next month. Thank you.